Hi, I'm Brian from Seoul Law Group. If you are an employer in Korea, you might be wondering, can I legally dismiss an employee just because they're not performing well? The answer is yes, but only if you meet strict legal standards. In this video, we'll break down exactly how Korean labor law views low performance dismissals and what you need to do to stay compliant and avoid a wrongful termination lawsuit. Let's start with the basics. Under Article 23, Section 1 of the Korean Labor Standards Act, an employee cannot be dismissed without justifiable cause. But here's the key. The law doesn't say just cause must be disciplinary. So yes, poor performance can be a justifiable reason for dismissal. But courts look at this very closely. So what actually qualifies as justifiable in a low performance case? The Supreme Court of Korea, in a 2021 case, laid out the criteria. Number 1, objective and fair evaluation, which means you need to prove the employee was evaluated based on clear, unbiased performance standards. Number 2, no reasonable expectation of improvement. The employee must have consistently underperformed for a significant period, and there must be little or no potential for future improvement. In making that call, courts consider 1, the employee's role and responsibilities, 2, how far below the standards their performance is, and 3, whether they were given training or a chance to improve, 4, their behavior and willingness to cooperate, and 5, whether internal procedures were followed. Let's look at 3 types of outcomes from Korean courts. Case number 1, dismissal upheld by the Supreme Court in 2023. The employee had worked at the company for 25 years, and over 11 years, they consistently ranked near the bottom. They were given 7 chances to improve through a performance improvement plan, but still failed. The court found the dismissal legal and justified. Let's take a look at case number 2. Lower court agreed with employer in 2023. The employee had repeatedly received low ratings. They ignored tasks, skipped work, and refused reassignment. The court said the company provided ample opportunity to improve, so dismissal was allowed. But not all cases go in favor of the employer. Let's take a look at case number 3, dismissal rejected by the court. An employee in an artistic troupe was dismissed after low ratings. But no chance to defend themselves, no appeal process, and no proof the evaluations were fair. The court ruled the dismissal invalid. In another case, the court noted that 5% of all employees always received the lowest rating. So the grade alone wasn't enough to prove poor performance. If you are an employer, here are 6 rules you must follow. Number 1, burden of proof is on you. You must prove the dismissal is justified, no assumptions. Number 2, use fair, transparent evaluation standards, which means avoid vague or subjective criteria. Employees should know how they are being evaluated. Number 3, conduct regular evaluations. One bad review won't cut it. You need a pattern of poor performance over time. Number 4, provide opportunities for improvement. This is non-negotiable. You must offer training, reassignment, a performance improvement plan. Number 5, track employee attitude. If they are refusing help or acting in bad faith, document it. It matters. And number 6, follow your own rules. Make sure internal policies and disciplinary procedures are clearly defined and followed. Dismissal for poor performance is possible under Korean law, but only if done correctly. If you are unsure whether a dismissal will hold up in a court, or if you're an employee facing unfair treatment, reach out to us at Seoul Law Group. We help both companies and individuals navigate the complex reality of labor law in Korea. Thanks for watching. If this video helped you, don't forget to like, subscribe, and drop your questions in the comments below. See you in the next one.